All righty. Good evening, everyone. I'm Tom Boak, Chairman of the Kennebunkport Planning Board. This is a virtual planning board meeting. We're using the Zoom conferencing format. Agenda is on the town's website, has information for the public needed for the public to participate. If you wish to participate through Zoom, you can join a Zoom meeting 923-7572-4765. You can also dial in by phone at 929-205-6099 and then give it that same Zoom meeting number. If you're conferencing by phone and watching this on cable or YouTube, you have to turn your volume down so you don't end up with feedback. As always, this is on channel 1301 and you can stream it on Kennebunkport Television on YouTube. During the meeting, the Planning Board and current participants are selected to be on screen with audio connected. All other participants will be blanked and audio muted, except when the board solicits public input. I ask the public to take turns when talking, otherwise, and we'll ask you to raise your hand, virtual hand, to be able to talk to this group. Anyway, excuse me. The bulk of these meetings, the meeting tonight is actually all public hearing, so we'll be opening it on each item. First off, we have the roll call. I see lots of cheery faces here, so I'm here, Tom Boak. Nina, I see Nina's here. I see her. Scott is
here.
There. Ed, I see Ed. Larry, yep, there's Larry. George.
Here.
And John. We've got a full
Here.
Super. Okay, so we're going to start with the first item. If Bud Brown is there. Has Bud Brown succeeded in dialing in? Well, yeah. Well, he was going to try to call in. I mean, he was not able to call in last week.
Yes. Hey, Tom. Tom, you want to do the minutes first?
Oh, I'm sorry. Of course I do. It's just someday she'll put it in the script I'm supposed to read to have the minutes.
Yes.
Even though it's a short version of the script. Okay. Does anybody have questions about the minutes of the last meeting? Hearing none, does anybody wish to make a motion?
I'll move to approve the minutes as they are.
I'll second.
Okay, so that's moved and seconded. So let's go through the people here. I'm in favor.
In favor.
Okay, so Nina?
Approve.
Scott? Yes. Ed?
In favor.
Okay. Larry?
In favor.
Okay, good. Very good. Now, we still do not have Bud Brown? Okay, I guess we're gonna have to move on. Do we have Bill Walsh? Okay, why don't we proceed to item 2, and if Mr. Brown shows up, we'll get back to his item.
Hey, Tom, before we do that, can I make a couple of comments?
Sure.
That I've noticed as we've been doing the findings of fact and these letters and so forth and the applications. I just want to make a comment about one, the letters of authorization. I think there's been a little confusion there. If we don't have both people on a trust, yes, we need a new letter of authorization. But I think we've asked for letters of authorization when an application comes back to us. If a letter of authorization is old, but it still covers the same issue, it's still good. It has not been revoked. I just want to say we don't need a new letter in that situation. Letters of authorization in Maine continue until they're revoked for the specific issue that they're covered for. The other thing I just wanted to talk about was I've noticed the findings of fact are getting kind of brief sometimes. And the findings of fact are the first thing, if there's a dispute, they're the first thing that a judge looks at to see why the planning board made the decision they made. So it's important not just to have all the facts in there, but to cover all the issues. For example, conformance in the riverfront zone, and saying that we find that it conforms, and so if there's a dispute about conformance, they know, particularly that the planning board did find that it conformed, and you might even put why it conformed to, a particular lot size, lot coverage or something like that. We really need to do more, I think, to explain why the decision is the way it is. So that's my 2 cents right now.
Okay. Well, I notice Mr. Walsh is there. So we are going to go to item 2 on the agenda, which is Aaron and Emily. It's number 200702, Aaron and Emily Cooper, Walsh Engineering Authorized Agent, site plan reviewed. The continued public hearing for approval to remove an existing stone seawall and replace it with new stone revetment of 5-foot diameter boulders on the eastern property line. So I guess, Bill, if you can just very briefly explain it, and then if anybody has questions, we can get it over to the public hearing eventually. So.
Okay. Thank you, Mr. Chairman. As you said, Bill Walsh with Walsh Engineering, and I'm here representing Aaron and Emily Cooper. We did, as you said, we met a couple of weeks ago with you and had some questions from the board. The project generally is just simple replacement of the existing revetment. We're taking stones that are in the revetment and basically upsizing them to be able to withstand the forces. And I thought we had some good questions at the last one, and I think we've tightened everything up, I hope, to the board's satisfaction. This was approved back in 2019, I believe it was. So it's a reapproval. The information that we did provide was the PBR, the actual signed PBR, which should be in the packet that you received. We did do a new agent authorization, which is signed both by Emily and Aaron Cooper as trustees of the Emily Cooper Revocable Trust. We have included the information on easements, and if I can share my screen real quick, I can, I don't know if we can, let's see. I can get possible to get the screen for a minute. Here we go. Thank you. 1 second. Not sure what it's sharing. Let's go there. Here we go. That right there is the updated agent authorization form that I just mentioned. The easement for the Eisenbergs, we just didn't get that in. Sorry, I'll get this at the right size. So this is the property to the north. We were looking for a 15-foot easement from the Eisenbergs to be able to basically get up to the property line, but be able to adjust stones as necessary right at the tie-in point. So this was not included in your packet. The unsigned one was included in your packet, but we obviously can include this when we go for our building permit. The Gorney easement is this one. The Coopers and the Gorneys are in the process of talking through this and getting where we need to be. And I guess what we are requesting is that this be, both of these easements, I guess, be a condition of approval if that is okay with the board. Soils map, I think Larry had a question about the soils map, and this is the actual property on the site. It does show beach sand here. This is the site. And I also did include what was an excavation photo. This is actually underneath the house of the Coopers. And it doesn't, I did observe this, but I don't have a photo of it, but I did see the excavation of this foundation down about 5 feet below, and it was all beach sand in there. We did not hit anything but that. So I feel pretty confident that we're good on the soils and the sand that are there. We did look at the basis of design as you asked for, and I'll step you very quickly through the methodology. We take a buoy station out here. This is actually the wave information from the Army Corps of Engineers. And this represents, go to the compass rose, this represents about 30 years of wave heights at that particular buoy. And we use this as the actual orientation of the property if it were to come in is somewhere in between here. So we used an actual wave height of about 6 feet, which I think is a little bit on the conservative side, and did our calculation on the stone size. This is Hudson's equation that we use, and you put in the parameters of the slope and the wave height, and we go through this calculation and determine a 3.8 foot diameter stone is what's necessary. We're using, that's at average stone size, so some could be larger and some could be smaller than that. And what we have done here, just zoom in on this a little bit on the cross section. I'll show you this real quickly. So we've called these out as the 5 to 6 foot diameter face stones, and we've actually added this in here to pin the two base stones together. Those will be pinned by stainless steel pins, and they will be epoxied into one another. So they become much stronger. And then we have the mass of the two stones essentially tied together on these lower stones. So I think that is pretty much what we have for this. And I'm sorry, one other thing I'll show you real quick, just so you understand that compass rose issue. We put that compass rose in here. So this magenta line is somewhere in here. It's right in kind of in between those two on the compass rose, as far as the direction that this would hit the beach. So we feel we're confident in those wave heights. And the other thing about those wave heights is those are the buoy wave heights that are out to sea quite a ways, which typically are higher. As waves get in, they actually decrease in size due to depth of the water. They're higher in the deeper waters. So with that, I will be happy to turn it back over to the board and answer any questions.
Okay, thank you. It's Larry, you had the most questions before, so I'll recognize you for starters.
Well, I really appreciate, Mr. Walsh, appreciate your updating the application. I mean, it looks great to me. You know, this is going to be quite an impressive revetment when you're done. So, you know, I'm good. It looks great. Thank you.
Thanks. Hey, Larry, one other thing that I did not point out is on the plan. You probably noticed that, but we did put the basis of design right on the plan.
I noticed that. Yep, I appreciate that. Yep, it looks great. Thank you.
It was a good idea.
Okay, does anybody else on the board have further questions for Bill?
I have a comment,
Sure.
Bill, on your construction easement. The last sentence does not make any sense.
Okay.
It's missing a verb somewhere. I think you want to say something about the owner's property at the end of that will be repaired to a similar condition. Otherwise, the sentence doesn't make sense at all.
You are correct. The word repaired was left out of that. So we'll get that straightened out. Thank you.
Okay. Hearing no one else, I guess I will reopen the public hearing So is there anyone out there would like to comment on this in the public? If so, raise your hand. Okay, well, in that case, I would suggest we vote on the project. So,
I'll make a motion to approve the project.
I'll second it.
okay, and now I'm going to go down the list again, which I've misplaced, of course, but. Okay, Nina,
Approve.
okay, Ed,
Proof?
Scott,
Approve.
I approved it also, Larry, of course, Larry.
Approve.
Okay, good. Well, in that case, it's approved. Larry, are you ready to read the finding of facts?
I've got it here. Yep. You want to do it now or you want to do it at the end, or should I just go ahead and read away? What's your preference?
Why don't we just read away when we're done?
Okay. So this is the finding of facts and decision concerning the application of Aaron Cooper and Emily Cooper as trustees of the Emily Cooper Revocable Trust Agreement dated April 30th, 2009 by Walsh Engineering Authorized Agent. The project is to remove the existing stone revetment and replace it with a boulder revetment in order to improve stabilization of the shoreline along Goose Rocks Beach at 165 Kings Highway. Following a site plan review pursuant to the Kennebunkport Land Use Ordinance on the 5th of August, 2020, and a public hearing held on the 19th of August, 2020, and continued on the 2nd of September, 2020, the Kennebunkport Planning Board makes the following findings of fact and conclusions and renders the following decision. Finding of facts are as follows. The site plan application replaces a prior application and its associated findings of fact and decision, which were approved by the Kennebunkport Planning Board on the 6th of February, 2019, and recorded at the York County Registry of Deeds on the 6th of March, 2019. Prior application has expired since the work was delayed by choice of applicant, hence the need for the current application. The applicant is Aaron Cooper and Emily Cooper as trustees of the Emily Cooper Revocable Trust Agreement dated April 30th, 2009, applicant with a mailing address of 31 Winthrop Road, Lexington, Massachusetts, 02421. In a letter dated August 28th, 2020, applicant has authorized Walsh Engineering to act as agent for this matter. The property has a street address of 165 Kings Highway, Kennebunkport, Maine, 04046, and is identified as map 33, block 1, lot 3 on the municipal tax assessor's maps. The property is located in the Goose Rocks resource protection and shoreland zones. The owner has demonstrated a legal interest in the property by providing a trustee deed recorded in the York County Registry of Deeds, book 1688, pages 920 to 921, dated September 12, 2014, and further as a result of the supplemental agreement regarding joinder of beachfront owner to beach use agreement recorded in the York County Registry of Deeds, books 17718, page 28, dated May 22nd, 2018. In addition, the beach use agreement recorded in the York County Registry of Deeds, book 16397, pages 492 to 828, and page 3 of the Schedule A to the beach use agreement. Beachfront owners, beach use agreement, beachfront owners clarifies that both applicant and both abutters, Gorney and Green Realty Trust, are all part of the beach use agreement. The property consists of 0.28 acres, which is about 12,197 square feet, more or less, for a single family residence. Since the lot area is less than 40,000 square feet as specified in the land use ordinance, and since the lot coverage is 25%, which exceeds the 20% maximum specified in the LUO, it is legally non-conforming. However, the project is limited to work only on the shoreline revetment, which does not increase lot coverage. Additionally, the property is legally non-conforming since the lot width of 100 feet is less than 150 feet specified in the land use ordinance for the shoreland zone. In an application dated July 15th, 2020, and supplemented with additional information on August 28th, 2020, applicant proposes to remove the existing stone revetment along the entire shoreline boundary of the property and replace it with a new boulder revetment. The new proposed boulder revetment will consist of a combination of geotextile fabric, a base layer of 10-inch stone, an intermediate layer of 3.5 foot to 4.5 foot diameter boulders, and a top layer of 5 foot to 6 foot diameter boulders. And additionally, the lowest 2 rows of 5 foot to 6 foot boulders will be connected together with 1-inch diameter by 36-inch long stainless steel threaded dowel rods, minimum 2 dowels per boulder. Epoxy will be used to secure the threaded dowels in each connected boulder. Details are per drawings included with the application. A Section 8 permit by rule application was approved by the Maine DEP on December 12, 2018. The adjacent neighboring property located along the north boundary at 167 Kings Highway, Kennebunkport, Maine, identified as map 33 block 1 lot 2 on the municipal tax assessors, is purportedly owned by Robert Eisenberg and Leslie A. Eisenberg, trustees of the Green Realty Trust. A 15-foot construction easement is proposed by applicant for purposes of working within the trust property for installing the new boulder revetment and stabilization. The adjacent neighboring property located along the southern boundary at 163 Kings Highway, Kennebunkport, Maine, as identified as map 33 block 1 lot 4 on the municipal tax assessor's map, is purportedly owned by John Gorney, Roberta Gorney, and Eric Gorney, the Gorneys. A 15-foot construction easement is proposed by the applicant for purposes of working within the Gorneys property for installing the new boulder revetment and stabilization. The applicant has requested no submission or performance waivers from requirements of the Kennebunkport Land Use Ordinance. Pursuant to the requirements of Article 10.10.a of the Land Use Ordinance Guidelines for Decisions, the Planning Board shall approve a site plan application unless it makes a negative ruling on one or more of the following identified findings, which would otherwise compel denial. A, the proposed use meets the definition or specified requirements set forth in the land use ordinance and will be in compliance with applicable state or federal laws, finding yes. The proposed use will not create fire safety hazards and will provide adequate access to the site or to the buildings on the site for emergency vehicles, finding not applicable. The proposed exterior lighting will not create hazards to motorists traveling on adjacent public streets and is adequate for the safety of occupants or users of the site and will not damage the value and diminish the usability of adjacent properties, finding not applicable. D, the provisions for buffers and on-site landscaping provide for adequate protection to neighboring properties from detrimental features of the development, finding not applicable. E, the proposed use will not have a significant detrimental effect on the use and peaceful enjoyment of abutting property as a result of noise, vibration, fumes, odor, dust, glare, or other cause, finding yes. F, the provisions for vehicular loading and unloading and parking and for vehicular and pedestrian circulation on the site and onto adjacent public streets will not create hazards to safety, finding yes. Comment, vehicle access and vehicle parking for execution of the project mostly will be on the owner's property and or on a butter's property. G, the proposed use will not have a significant detrimental effect on the value of adjacent properties, nor has a significant detrimental effect which could be avoided by reasonable modification of the plan, finding yes. H, the design of the site will not result in significant flood hazards or flood damage and is in conformance with applicable flood hazard protection requirements, finding yes. Comment, the proposed new revetment will improve protection from flood hazard. I, adequate provision has been made for disposal of wastewater or solid waste and for the prevention of ground or surface water contamination, finding not applicable. J, adequate provision has been made to control erosion or sedimentation. Finding yes. Comment, erosion and sedimentation control plan included as Exhibit L of the application and on drawings is included with the application. K, adequate provision has been made to handle stormwater runoff or other drainage problems on the site. Finding yes. L, the proposed water supply will meet demands of the proposed use or for fire protection purposes. Finding not applicable. M, adequate provision has been made for transportation, storage, and disposal of hazardous substances and materials as defined by state law. Finding not applicable. N, the proposed use will not have an adverse effect on significant scenic visas or on significant wildlife habitat, nor will have such an impact that could be avoided by a reasonable modification of the plan. Finding yes. O, the proposed use will not cause unreasonable highway or public road congestion. Finding yes. Comment, vehicle access and vehicle parking for execution of the project mostly will be on owner's property and or on a butter's property. P, existing off-site ways and traffic facilities can safely and conveniently accommodate the increased traffic generated by development as far away from the development as the effects of the development can be traced with reasonable accuracy. Finding not applicable. Okay, so then when a proposed development will be located within the shoreland or resource protection zones, in addition to the requirements of the Kennebunkport Land Use Ordinance, Article 10, the townwide regulation in Article 6, the performance standard for specific activities and land uses in Article 7, approval of the development will also require that the board makes positive findings based on the information presented that the proposed use, A, will maintain safe and healthful condition. Finding yes. Will not result in water pollution, erosion, or sedimentation to surface waters. Finding yes. Will adequately provide for the disposal of all wastewater. Finding not applicable. Will not have an adverse effect on spawning grounds, fish, aquatic life, bird, or other wildlife habitat. Finding yes. Will conserve shore cover and visual as well as actual points of access to inland and coastal waters. Finding yes. Comment, revetment will minimize disturbance to the shoreline during and after completion of construction. No visual or actual impediments of access will increase as a consequence of project execution. F, will protect archaeological and historic resources as designated in the comprehensive plan. Finding not applicable. G, will avoid problems associated with floodplain development and use. Finding yes. H, is in conformance with the performance standards set forth in section 5.6, erosion and sedimentation control of the Kennebunkport Land Use Ordinance. Finding yes. So any negative finding by the board means the application has been denied. The application is otherwise complete. Conclusions. Article 10.10.a of the Land Use Ordinance mandates that the planning board shall approve a site plan application unless it makes one or more identified findings that would otherwise compel denial. As noted above, the board makes no such findings. Decision to site plan application identified above is hereby approved. So conditions of approval, if any, pursuant to Article 10.11 and 10.12.e. First, the applicant pursuant to 10.12.e shall notify the planning board prior to the transfer of rights to construct an approved project. Second, the applicant must enter into a 15-foot construction easement with either the abutter Green Realty or the abutter Gorneys, or with both abutters, in order for the applicant to expedite work associated with the new boulder revetment. Copies of the construction easements must be provided to the Code Enforcement Office before any work is to commence on the properties of the applicable abutter. If no construction easement is obtained from either Green Realty Trust or the Gorneys, the applicant must work within the boundary lines of the property owned by the applicant. Next, the applicant must record a copy of the decision and provide proof of such recordation in the form of a copy thereof attested by the Register of Deeds before any permits may issue or before any construction activity may commence. And last, number 4, the applicant will comply with all terms and conditions of the Town of Kennebunkport ordinances, as well as the Maine DEP and U.S. Army Corps of Engineer approvals, dated September 2nd, 2020. That's
Okay. So do I hear a motion to approve that as read?
I'll make a motion to approve as read.
I'll second it.
Okay.
Good. All right, so I'm going to go through the list as usual. I'm in favor of that motion. Nina,
In favor.
Scott,
In favor.
Ed? You're muted, Ed.
Sorry, Tom, in favor.
Okay, Larry.
In
Okay.
favor.
All right, good.
Hmm.
Okay, now, I thank you, Mr. Walsh. We're done with Mr. Walsh. Has Bud Brown shown up? Okay, well then, why don't you bring forward the Nonantum Resort, please. Okay, this is item 200201, Seaside Hotel Associates, DBA Nonantum Resort, Site Plan Review. This is the continued public hearing for approval to add a new roof over an existing deck. It includes stairs to an open air deck near the existing in-ground pool. So if you could proceed, Tina, and just give a brief explanation. It's got, we all have heard it once, but just in case.
Certainly. And also, John Einseidler's on the call. Would you be able to bring him forward as well?
That'll be not a problem, right?
Thank you. Well, good evening, everyone, and thank you, ladies and gentlemen of the Planning Board, for taking the time to review the information that we had submitted in regards to adding a new roof over an existing deck in our pool area. So I believe when John gets on the line, he has the plans on his computer, and if we could just do a share screen, there we go, so that we can show everybody what's happening here. As you can see, the existing pool area, we're asking for two separate things, not only to add the deck over the existing landing that's there, but also to take down the fence that is existing, remove a shuffleboard court, and add a concrete apron to the edge of the pool area, and then another in a little grassy area, and install a new fence in its completion, just to give us a little bit more room around the pool area. So as you can see, we're actually taking away some lot coverage just by a little bit, but nonetheless, it is less. So we're working on being able to offer more options for our in-house guests, as the pool is not open to the public.
Okay.
John, do you have anything you'd want to add?
Nope.
Okay, George, do you have some questions on this, or you pretty well?
I don't. This is our third meeting on it. I think I'm pretty clear on
I
it.
understand. I do have one question for Werner. Now, I know that the Nonantum has, a portion of Nonantum is in Riverfront, and a portion is in Village Residential. I believe the pieces we're talking about are all in Riverfront, therefore does not need the shoreland except shoreland overlay.
Correct, yes, because it's a riverfront general development, so it doesn't, need any of the separate standards relative to shoreland or RP.
So that's a slight mistake in the application, Tina.
What's that?
There's an X under shoreland on item.
Okay.
Tom, this is Ed, and Werner, question for you too. If you look at the map that's on the town website for the zone,
Oh, I see.
it shows along much of the riverfront area, and I think including where the Nonantum is and the other application that's before us, it does show distinctly shoreland and RP in front of, along the riverside edge. Now, up along other portions of the riverfront, it's more like Dock Square, and there's none shown. In fact, in the other application that we've skipped over tonight, he's actually included a copy of that section of the map, and it shows that there's shoreland. So I'm getting a little confused by that distinction.
Yeah, let me, well, I wasn't prepared to pull up the shoreline zoning map for you this evening, but
No, I understand, and maybe we take this offline, but it seems different than we've been talking about it in the past. And
so here's what's a little bit odd with, what you're seeing on some of the maps. So, the riverfront zone and Dock Square are both, listed as general development district in terms of how they're treated. But here's what's tricky is that we have Village Residential, which is on the opposite side of the street. Now, arguably, Village Residential is still subject to your shoreline zoning and RP overlay. So the question is, well, what do you do with the map, right? So we have these odd kind of little rifts, that are on the opposite side of the street that technically are still part of the shoreline zone overlay. So you have this weird stretch, that's along the river. And again, it seems somewhat counterintuitive to how you think about it, but you've got the Nonanum hotel property. It's in the riverfront. It's in general development. But then what do you do with this little sliver that's across the street that's in VR? And now that, in our descriptions has not been removed from, the shoreline zone overlay. Although from a mapping perspective, it would, be neater and cleaner if it was, but it's not in the description. And so that's why we have sometimes there's little slivers across the street from it.
So she could just as well leave the X there, and I bet George has already written the shoreland piece of the finding of facts.
In
I
fact, George has.
don't think it's affecting any of the compliance issues. It's really just the formality of how we capture the findings here. And
that's correct. Yeah, it doesn't. I would agree with that. It doesn't affect any of the compliance. Any of the compliance questions or issues here. I think practically speaking, it means you've got a section of the FOF that probably doesn't have to be included.
But it doesn't hurt either.
Correct. Yeah. In this
So why don't we'll just
particular case, it doesn't have any effect on the property.
So Tina can leave the X there, and George can leave his section 12 or whatever. Okay.
It makes for a riveting read.
Oh, I'm sure. We're just looking forward to that riveting read here in a few minutes.
We all are.
I had noted that in some past readings of findings that there have been board members who have summarized the shoreland zoning component pieces in having a general statement that all of the standards, and then just listing the general the standards, and that there have been no negative findings. Now that it's entirely up to you all how you read that, but we have had board members who have abbreviated the full read of it.
How would they do that, Werner? I mean, what might one say?
Well, when they got to, for instance, the guidelines, for decisions, as listed in Article 10.10A of the Land Use Ordinance, and as such have found, in all of those standards that there are no such negative findings. It's just.
I would think where we, in some of them, we put in a comment or a description beyond not applicable.
That's correct. So where you would have as separate comments, you would want to go through a process of reading every one of those individually. But if you found yourself in a circumstance where you had no comments in any of the categories and they were all positive, it's my understanding that you could summarize those with a statement that,
Yeah,
Not me. I'm reading the whole thing.
All right, well,
Anyway, first things first, I need to reopen the public hearing just in case someone is out there in the public. Okay. Okay. Well, in that case, I will close the public hearing and, okay, well, good for him.
Hi,
Okay.
Bud.
So, all right, we will then, I will happily accept a motion to approve this, the Nonantum item.
I'll make a motion to approve the Nonantum proposal.
Second,
All right, so I'll going through the list again. I'm in favor. Nina,
In favor.
Scott,
In favor.
Ed,
In favor.
Larry.
in favor.
Okay, it is approved. And,
Yay. Thank you.
okay, George, you want to read or do you want to show, or do we get Bud up since we got him? now?
It's up to you, Mr. Chairman.
All right.
I'm
I'm gonna
merely a servant of the group.
bring Bud forward for the, excuse me, Chicks Marina update. So if you could bring Bud Brown, and thank you, Tina.
Great.
See you
Thank you,
again sometime.
everyone. Okay. Take care. Thank you all. Have a great
Bye.
evening.
Can you hear me? Oh, boy.
Yeah, you can, we can, I heard that you, Bud?
It
We can
is.
hear you, bud.
I
Yeah.
apologize. I tell you, I'm so bad at this. It's ridiculous.
Okay, well, so if you could briefly just, there you are. Okay,
That was-
hey,
I swear.
fantastic. So if you could describe the dredge and, you know, we did a initial public hearing last time in your absence. So we just need to have you describe the dredge and what's going to happen.
Right. Apparently, I didn't realize I had to notify Lisa like right before the, I was late. I got it, but apparently she got the message to you that I was working out of town all week. I had no cell phone.
Yes, yeah. So we understood that. We just opened the public hearing, got no additional public comments, and you've answered some of the comments that came out of our review the last time, so.
Right, so you got the letter I got from Bob Green that you can do part of the project and not all of it, and
Right.
it's still fine. So basically, and I don't know how to get off the screen so I can look at the amount of dredging that's gonna be involved in it. I'm a mess here. I don't know. Maybe if I hang on, yeah, here we go. I was going to open this in my other. I was going to put up the plan view so I could talk about how much material we were going to dredge. Okay. Yeah, I'm on my computer. Here we go. Now I think I should be able to move this to the other screen, correct? Right, okay, boy, I appreciate you guys talking me through this because I have it up on my other screen and
There it comes.
There you
We
go.
got-
There's hope for me. So as you can see, that's the dredge window. I can't tell you the amount of material, but the new view takes out that bulkhead we're going to build, and basically it's going to be a box cut to that right next to the paved launch ramp, and it's going to encompass that area, and that's it. It's going to go to minus 6 feet plus a 1 foot overdig.
Okay, and you have approval of the Corps of Engineers for
Right,
dumping?
I'm gonna have to, we have the DEP permit. The Army Corps permit is still in effect, but in October, the programmatic general permit is gonna be updated. And at that point, I just have to contact Jay Clement at the Corps and he will update their approval. And I will
Okay.
submit that when I get it. And we can't dredge until November anyway, so it'll be in place well before the actual activity will happen.
So should that be a condition on the finding of facts that that has been re-upped by the time? Probably should add something to that effect, Scott.
Yes, I agree.
Okay.
And I'll be able to do that just by an email, which I will forward to the town office too.
Yeah, so prior to actually getting the permit, you'd have to have it approved, but that's not, it doesn't affect what we're doing here today. So, okay, does anyone have any questions here for Bud?
Just a curious one. How do you dredge around pilings?
They will pull the pilings and replace them.
Oh, okay.
And typically what's done is that any slips that are, or floats that are in the way will be taken out and put on moorings or taken to one of the adjoining marinas. That's what's happened in all the dredging.
Okay.
Okay. All right, now, while we were discussing Nonantum, we were talking about the resource protection and shoreland. So I guess we need to figure out what we need to do here. Your application actually, I think, said that it was both. And I think Werner would say it's neither, so. And the
Tom, as I mentioned, he's included, if you could show page 11, it actually shows the RP and shoreland sliver that we're talking about.
oh yeah, look at that. That stupid little crosshatch thing.
Yeah.
Yeah. Okay, well, so I guess it's fine, and I'm sorry, Scott, but you'll have to put that stuff back in.
No, that's fine. That's fine.
So, yeah, and along with the condition that we just talked about, I guess. So, I guess we need to reopen the public hearing, or try to, unless somebody else has stuff to discuss here. Any public people out there? Bud, you? Yeah, good. Okay, good. So accordingly, let me take I'll move approval of this item.
I'll second that.
Okay, so I'm going to go through the list here. I'm in favor. Nina's in favor. Scott?
In favor.
Ed?
In favor?
Larry?
In favor, and we're approving the application, right? Is that it?
Yeah.
Okay.
Yeah.
Yep.
We
I'm
have,
in favor.
we have to make some tweaks to the finding of facts that Scott just distributed, so it'll be read the next time.
Okay, good deal. Yep.
So that'll be fine. Which, now we still held George responsible for a finding of facts, but I guess we're done with you, Bud. Thank you.
Well, thank you. I apologize.
We taught you some important new things to do, tricks. So we're all set next time.
Great job.
Thank you.
Okay.
Yeah.
Thank you. Now, is Jim Logan out there? Jim Logan is my fourth item. Is he around? Okay, thank you.
How we doing?
Hi, Jim.
How's everybody tonight?
Excellent.
Excellent.
Good.
So proceed, James.
Okay, thank you. I am back this evening with the board. I appreciate your time and your attention. Our first application on this particular project was for Jim and Susan McMahon over on Northwoods Drive at 18 Northwoods Drive in the old Santee Freeney subdivision there. We were first back to you guys last June 24th last year, and we brought to you several items for discussion. At that time, we were talking about removing a shared easement for a driveway for two adjacent lots that are both owned by the McMahons. That, under further consideration, is now going to be reversed, and they're going to be willing to share the driveway and leave everything just as it was. So that initial proposal we brought before you, we are now removing that request in the 2020 application that we have submitted. We are revising or asking for a revision of the setbacks that were shown on the original plan by Lower Village Survey. Leon Blood had a plan that showed 75-foot offsets to the stream within the wetlands and all associated wetlands or all the forested wetlands on this property. That was not a requirement at all, and I got a DEP review of the wetlands and shoreland zoning. I've reviewed this with Warner Gilliam at length as well. So what we're attempting to do is, and Leon's revised plan shows the 75-foot required setback to the stream all the way through the property. However, the setbacks to the wetlands have been removed. Okay, so that was the second point. And then the third item revolved around, if you folks remember, we were talking about a possible easement for a septic system that was located. Let me see if I can get this up to where you guys have this map. This section of the map, I don't know whether you can see that. There's this cutout, and that's the original division line. And the septic system for the house over here was in this cutout piece. We've elected to go ahead and replace the system. That original system in that piece of property was from 1988, and upon further consideration and quite frankly input from you folks about the curiosity of an easement, the McMahons elected to replace the system, and it is now easterly of the new proposed lot line that runs up the edge of the driveway, so that it is altogether on the lot that has the house and would no longer, it is no longer connected to what's across that lot line. So the need for an easement that we first requested in 2019 is no longer imminent. It's a moot point. We now are just proposing the revision of the lot line, and septic systems are all addressed and taken care of. So we're proposing the new lot line revision as Leon shows it. Those are basically the simple aspects of this. Some parts of it got much less complicated. Again, we're sharing the driveway easement just as it was originally represented. There will be no additional stream crossing at this time, although we did vet that as a possibility. Let's see, the only changes required and the only consideration of the board at this point really is this adjustment of the lot line between, which is a common lot line between two lots in common ownership. So this is a change that really affects none of the abutters. I don't know whether it constitutes as bigger than de minimis because it is a minor amendment to a subdivision plan. We do need the board's review and signatures in order to record this new plan at the registry. And I guess I would ask, would a public hearing be necessary because no abutters are affected by it? The other point to bring is that Leon did revise the net lot area calculations in the area calculations box on the plan, and that transferred a portion of the upland from one lot to the other. Both lots are still far in excess of the minimum required for that zone. So I trust that that is adequate for description for the board. It's a pretty simple one to serve up to you folks. Leon has a very busy plan here. He included a portion of the original subdivision plan in the corner of his plan this time around, which showed the original plan approved in '92, I believe it was, for the final approval anyway. The amended approval was in '92, a plan put together by Stevens, Morton, Rose, and Thompson, SMRT. And because this is a fairly busy plan and has a lot of notes on it, the signature box is pretty small, so I would ask that you guys sign small. Okay, and that's what I have for a presentation tonight. If there are any questions, I would happily answer them.
Tom, I don't know if the board wants or not, but I can do a screen share of the plan if that would be helpful.
I have a copy here, which I don't know if other people wish to. That's
I would benefit from that, Werner. This is Ed. But I would ask, can you just clarify for me, Jim? You said there's one thing that you want to ask of the board, and then I heard there's three things that you're asking of the board.
We came to you with three things earlier, actually. No, I guess technically it's two things because we are revising the setback to the wetlands. That's not really a requirement of the board. We've just revised it based on a DEP interpretation that was never obtained previously. Matter of fact, the original subdivision plan, if you really look hard at it, if Werner does put it up on the screen, showed a 25-foot setback to the stream, believe it or not. The original approved plan.
We actually had this discussion last time, and I think we all agreed at that time that it wasn't a hard and fast requirement, but it was
correct.
It was a better thing to be doing, and now
right.
I understand you've reconsidered, and that's fine too.
Right.
To make things simple though, the last time, I'm trying to bring this up a level and say, what we approved last time included a plan. You've come back with an update to that.
We didn't approve anything.
There was no approval last time. We as a matter of fact, I apologize to the board and to the client because we were intending to submit to Lisa Harmon and Werner Gilliam a request for tabling the original application. You're seeing a brand new application from 2020 because unfortunately I missed the deadline for that request for tabling, and therefore we had to reapply as a brand new application. However, the issues are similar. We've removed a couple of them. Like I say, the shared easement for driveway goes away, so that's not even in your review anymore. It's strictly the 75-foot setback to the stream instead of what was to all of the wetlands and the revised lot line. And that's really all that the board needs to consider today.
You're not asking for approval now. You just want the board to consider some change?
I'm asking for the board to consider the revision to the 75-foot setback as shown on the plan and the new lot line as we depicted it on the plan. Yes, and God knows if it could be done tonight, I'd love to do that. But I had the impression, because the agenda lists this as, I believe, an initial review, it seems like I'm going back to square.
Well, you're confused, but I am too. That's maybe
I'm not
the same
confused.
point of confusion. Are we
There's no
asking for a
confusion.
change, or is this a brand new application?
It's a brand new application, but it's still a minor subdivision amendment. It's a minor amendment to a pre-existing subdivision approved plan. That's all. And the only thing in the board's review is the 75-foot setback to the stream, which has changed modestly from the original plan, as well as the lot line that is just slightly westerly of the driveway entering the property.
There's only 2 changes to the original approved subdivision plan. Is that correct?
That is correct, because I just got done saying that the shared easement that we initially discussed in last year's application is no longer of interest, and it's a moot point. That's the third thing that you don't have to think about any longer. I'm pointing out differences between last application and this one.
I understood. But you're asking for our approval of these 2 changes from an original subdivision approved plan.
Correct.
Thank you.
Okay. So I think that what we need to do is, it is obviously a minor subdivision, which means it doesn't have to go through a preliminary and final application. But I guess, Werner, you can bring down the picture. We can, I think we
Okay.
can. Anyway, so what we need to talk about here is the board, I think still, my feeling is I still want to see a public hearing on this, but maybe we don't need 2. I don't know what anybody else thinks on the topic.
I agree.
Well, I think we need to have a public hearing, yeah. I mean,
Yeah, I mean, I realize that it doesn't really affect any public, you know, but I think as such, you know, we've always had public hearings on things. So
yeah.
I don't see that there's a big reason we need to do a public hearing next time and then a second continued public hearing particularly.
I would agree.
Yeah.
I appreciate that. Thank you.
Okay, but so I think what we need to do on this, unless somebody has further questions for Jim, is to approve this application as complete and have a public hearing on the, whatever, 17th,
16th.
16th. Yeah. You don't like my 15-day, no, okay.
I have just a point of clarification.
Sure.
It looks to me on Leon's drawing that these 2 pieces are owned by different entities. One side is owned by Thomas or James and Susan, and the other is owned just by Susan.
On a technical point, that is correct.
We're approving the subdivision, right? So
That doesn't matter.
so I don't, so there are no deeds in this. It's just a subdivision, an existing subdivision we're making a modification to.
I mean, ultimately, you know, one piece that the board doesn't see, but that will happen is that, you know, once you get an approval for, you know, a modification of the lot lines, then, you know, along with the recording of a plan, there'll need to be new deeds will need to be drafted, and recorded to go along with that as well to reflect the revised lot lines. So, but that's not something that that comes before the board. But that's just that, that's a point of order that happens after this approval has taken place.
Thank you, Warner.
Okay, so we out of questions for Jim at this point, I guess. So somebody want to move that this is a complete application for a minor subdivision amendment?
So moved.
Second, please. Well, I'll second it. What the heck? Okay, so I'm in favor. Nina?
Wait a minute, Nina.
She's muted, but
Sorry, muted. I'm in favor.
Scott,
Yes.
Ed,
In favor?
Larry.
In favor?
Okay. Now, I need a case manager. Oh, look at the number of hands going up. Okay, John has volunteered. I saw that. No taking it back now. Okay, so Jim, we'll see you in 2 weeks, and we'll have just one. I think we'll probably end up just having one thing. And the case manager, in this case, I end up writing a letter. I don't know that, do we, oh, what was, no, it's a finding of facts because it's a final, right?
It's a finding.
It's
It's
a
a
finding of facts, but it's a subdivision finding of facts, which is different from from our regular findings of facts. But
correct.
so, with that being said, I guess that there's no delaying it, George. Thank you, Jim.
Thank you very much, board members. Have a great night.
All right.
Thank you.
And
Oh,
George,
the best part's coming up right now.
yeah, this is it. The best part. Let's hear
I
it.
will try to read rapidly. How about that?
Good. That would be nice.
Kennebunkport Planning Board findings of fact and decision approval of application of Seaside Hotel Associates Limited, doing business as Nonantum Resort, 95 Ocean Avenue, Kennebunkport, Maine 04046. To construct an open roof deck over an existing deck and extend a pool apron while removing a shuffleboard court. Following site plan review pursuant to the Kennebunkport Land Use Ordinance held on 18 March 2020 and a public hearing held 19 August 2020 and continued on 2 September 2020, the Kennebunkport Planning Board makes the following findings of fact and conclusions and renders the following decisions subject to the conditions enumerated below. Findings of fact are as follows. 1. The applicant is Seaside Hotel Associates Limited, doing business as Nonantum Resort, with a mailing address of P.O. Box 2626, Kennebunkport, Maine 04046. 2, the applicant is represented by Tina Hewitt-Gordon, General Manager. 3, the property has a street address of 95 Ocean Avenue, Kennebunkport, Maine 04046. 4, the property is identified as Map 8, Block 1, Lot 13 on the Municipal Tax Assessor's maps. 5, the property is located in the riverfront zone as well as the shoreland zone. The proposed construction is within the 75-foot setback requirement. 6, the property consists of 3.54 acres, more or less. 7, the owner, Seaside Hotel Associates Limited, has demonstrated the legal interest in the property by providing a copy of a deed recorded in York County Registry of Deeds, Book 7096, pages 121 to 124. 8, applicant has submitted a site plan application dated 4 February 2020. 9, the applicant proposes to construct a rooftop over an existing deck. The constructed rooftop will also be used as an open-air deck and will be accessed by a stairway. The new rooftop deck will be constructed directly over the existing deck footprint, which is 51 feet 7 inches by 16 feet 5 inches. 10, the applicant proposes to remove an existing 301.2 square foot concrete shuffleboard court and a 224.3 square foot concrete apron to extend the pool area and a 73.3 square foot stone retaining wall. The resulting construction will reduce the impervious area by 3.6 square feet. 11, applicant has requested no submission or performance standard waivers from requirements of the Kennebunkport Land Use Ordinance. The site is fully developed and no waivers are necessary. 12, Pursuant to the requirements of Article 10.10.a of the Land Use Ordinance, Guidelines for Decisions, the Planning Board shall approve a site plan application unless it makes a negative ruling on one or more of the following identified findings which would otherwise compel denial. A, the proposed use meets the definition or specific requirements set forth in the Land Use Ordinance and will be in compliance with applicable state or federal laws. Finding yes. B, the proposed use will not create any fire safety hazards and will provide adequate access to the site or to the buildings on the site for emergency vehicles. Finding yes. C, the proposed exterior lighting will not create hazards to motorists traveling on adjacent public streets and is adequate for the safety of occupants or users of the site and will not damage the value and diminish the usability of adjacent properties. Finding not applicable. D, the provisions for buffers and on-site landscaping provide for adequate protection to neighboring properties and from detrimental features of the development. Finding not applicable. E, the proposed use will not have a significant detrimental effect on the use and peaceful enjoyment of a budding property as a result of noise, vibrations, fumes, odor, dust, glare, or other cause. Finding yes. F, the provisions for vehicular loading and unloading and parking for vehicular and pedestrian circulation on the site and onto adjacent public streets will not create hazards to safety. Finding not applicable. G, the proposed use will not have a significant detrimental effect on the value of adjacent properties, which could be avoided by reasonable modification of the plan. Finding yes. H, the design of the site will not result in significant flood hazards or flood damage and is in conformance with the applicable flood hazard protection requirements. Finding not applicable. I, adequate provision has been made for disposal of wastewater or solid waste and for the prevention of ground or surface water contamination. Finding not applicable. J, adequate provision has been made to control erosion or sedimentation. Finding yes. K, adequate provision has been made to handle stormwater runoff or other drainage problems on the site. Finding not applicable. J, the proposed water supply will meet the demands of the proposed use for fire protection purposes. Finding not applicable. M, adequate provision has been made for transportation, storage, and disposal of hazardous substances and materials as defined by state law. Finding not applicable. N, the proposed use will not have an adverse impact on significant scenic vistas or on significant wildlife habitat, or will have such impact that could be avoided by reasonable modification of the plan. Finding yes. O, the proposed use will not cause unreasonable highway or public road congestion. Finding not applicable. P, existing off-site ways and traffic facilities can safely and conveniently accommodate the increased traffic generated by the development as far away from the development as the effects of the development can be traced with reasonable accuracy. Finding not applicable. 13, when a proposed development will be located within the shoreland or resource protection zones, in addition to the requirements of the Kennebunkport Land Use Ordinance, Article 10, the townwide regulations in Article 6, the performance standards for specific activities and land uses in Article 7, approval of the development will also require that the board makes positive findings based on the information presented that the proposed use A will maintain safe and healthful conditions. Finding yes. Will not result in water pollution, erosion, or sedimentation of surface waters. Finding yes. Will adequately provide for the disposal of all wastewater. Finding not applicable. D, will not have an adverse impact on spawning grounds, fish, aquatic life, bird, or other wildlife habitat. Finding yes. E, will conserve shore cover and visual as well as actual points of access to inland and coastal waters. Finding yes. F, will protect archaeological and historic resources as designated in the comprehensive plan. Finding not applicable. G, will avoid problems associated with floodplain development and use. Finding yes. H, is in conformance with the performance standards set forth in Section 5.6, Erosion and Sedimentation Control of the Kennebunkport Land Use Ordinance. Finding yes. Any negative finding by the board means that the application has been denied. The application is otherwise complete. Conclusions. Articles 10.10.a of the Land Use Ordinance mandates that the planning board shall approve a site plan application unless it makes one or more identified findings that would otherwise compel denial. And as noted above, the board makes no such findings. Decision. The site plan application identified above is hereby approved. Conditions of approval, if any, pursuant to Article 10.11 and 10.12.e. 1. The applicant pursuant to 10.12.e shall notify the planning board prior to the transfer of rights to construct an approved project. 2. The applicant must record a copy of this decision and provide proof of such recordation in the York County Registry of Deeds before any permits may be issued or before any construction activity may commence. 3. The applicant shall comply with all terms and conditions of the Town of Kennebunkport ordinances dated 2 September 2020. How about that?
That was an awesome reading, I'll have to say, for speed. Anyway, so do we have a motion to approve it as read?
I'll make a motion to approve. Second.
Okay, Good enough. Well, oh, right. So I'm in favor. Nina,
In favor.
Scott,
Yes.
Ed,
In favor.
and Larry.
In favor?
All right, so we have two findings to get signed tomorrow, or I guess tomorrow or Friday at Town Hall, if you can pull it off. I won't be there till Friday, Warner, but we need to get it signed again. It's just the two,
Yep.
two of the three. And
Fine
I
with
guess I'll take one more motion.
Motion to adjourn.
I'll
Second.
second it. And everybody's in favor, I bet.
Yeah.
Okay, thanks guys. I'll see you
Night
next
all.
time.
Thanks,
Good night,
Tom.
everyone.
Thanks.
Good
Good
night.
night.
Night.